Kashi Vishwanath Temple Gyanvapi Mosque is in news once again. The Allahabad High Court has put on fast track a suit that was filed 3 decades ago back in 1991 by Hindu worshippers seeking the right to worship in the Gyanvapi Mosque and the restoration of the temple at the disputed place. Now, this entire legal battle is a complicated one, and there are multiple orders spanning over 3 decades and multiple suits filed over this one plot on which the temple and the mosque currently stand. So in this video, I'm going to try to simplify it all for you. Now, the legal battle around the Gyanvapi Mosque dates back to 1991, as I mentioned. The original suit in this case was filed in 1991 by the devotees in the name of the deity Swayambhu Lord Vishweshwar, demanding that they should be allowed to renovate and reconstruct their temple because it was built at the site of a temple on Aurangzeb's orders. Now, while this suit was pending, the Gyanvapi Mosque's management committee, which is Anjuman Intizamiya Masjid, managed to get a stay on the proceedings from the Allahabad High Court in 1998. The committee had alleged that such a suit is barred by the provisions of the Places of Worship Act. I will tell you more about this law in just a bit. Now, while this stay continued by the Allahabad High Court for the next 2 decades, another attempt was made through an application filed in December 2019. This was a month after the Supreme Court verdict in the Ram Janmabhoomi Babri Masjid case. Now, despite the High Court's 1998 stay, the Civil Judge Senior Division, Ashutosh Tiwari, allowed the application for an ASI survey of the Gyanvapi complex in April 2021. The Allahabad High Court stepped in once again, criticized the order and stayed it on 9 September in 2021. Now, just to let you know, this suit is different from the one in which you might have seen a survey being conducted in Kashi Vishwanath Temple, Gyanvapi Mosque, and a shivling being found. I'm sure you've seen that news. But that was a different suit. So that was a suit filed in August 2021 in another local court in Varanasi by 5 Delhi-based Hindu women demanding permission to worship the Ma Shingar Gauri, Lord Ganesh, Lord Hanuman, and Nandi idols allegedly located inside the mosque. So that's a different suit. And in this suit, the second suit in May 2022, the court ordered videographic survey of the Kashi Vishwanath Temple Gyanvapi Mosque had reported a structure claimed to be a shivling by the Hindu side and a fountain by the Muslim side inside the mosque premises. Then earlier this year, the Allahabad High Court had set aside a lower court order and ordered a scientific survey including carbon dating of the shivling. Now, the court had passed the order in the same suit filed by the women seeking the right to worship, and in May this year, the Supreme Court had deferred the implementation of the High Court order. But this, again, like I said, this background was just for you to understand that these are 2 different suits. Now, the Allahabad High Court's order, the latest order, has come in the main suit. That's the first one that I mentioned earlier. And while arguing before the High Court, the parties came to the court with different interpretations of the Places of Worship Act 1991. Now, let me tell you a bit about this law as I promised. It prohibits conversion of places of worship like churches, mosques, or temples to a place of worship of a different religion. So it sort of freezes their character in time as they were on 15th August 1947. It also says that any court proceeding regarding any such conversion would cease after the act comes into force. But the law exempted the Ram Janmabhoomi Babri Masjid dispute and any court proceedings concerning it, which is why those legal proceedings continued. However, the High Court has now opined in its order passed on Tuesday that while the Act, this 1991 law, clearly defines conversion and place of worship, it does not define religious character of the place of worship. This phrase religious character, it does not define. That is what the High Court feels. It said that while the law defined places of worship such as temple, mosque, gurdwara, church, monastery, etc., it did not define religious character. It felt that it was for the court to find out from the facts and circumstances of each case as to the religious character of the place of worship. It pointed out that the plaintiffs in the case had not demanded conversion of any place of worship, but a declaration on the religious character of the plot in question. So one of the issues that the plaintiffs had raised was regarding the declaration on the religious character of this disputed plot. The court felt that the 1991 law is not an absolute bar on the parties approaching the courts after its enforcement, seeking their right as to the place of worship or defining religious character of any place of worship. It pointed out that one such bar is under Section 4, you can see it on your screens right now, in a case where a religious conversion has taken place before the commencement of the act and a party has not approached the court. So the Place of Worship Act 1991 also has certain exceptions listed down under the law. So the court felt like there were some exceptions that it could probably look at. The court now held that the religious character of the disputed place as it existed on 15th August 1947 is to be determined by documentary as well as oral evidence led by both the parties. So it allowed the trial court to hear the matter and said, and I quote, either the Gyanvapi compound has a Hindu religious character or a Muslim religious character. It can't have dual character at the same time. The religious character has to be ascertained by the court considering pleadings of the parties and evidences led in support of pleadings, unquote. The court also said that the dispute raised in the suit is of vital national importance. It said that it is not a suit between two individual parties. It affects two major communities of the country, and it asserted that in national interest, it is required that the suit must be proceeded expeditiously and be decided with utmost urgency with the cooperation of both the contesting parties. So now the High Court has asked the lower court to look into the suit expeditiously and not delay it any further because, as I mentioned, the suit was actually filed way back in 1991. So this has sort of opened and set the suit on fast track in a way. We will, of course, keep an eye out on what happens in this suit over the next few months. So do keep checking out our YouTube channel and our website for updates on this case. Thank you so much for watching.